just wanted to show you some examples of the trade very quickly. Ask them please to take the core bundle tab 3. This is our skeleton argument for the appeal, and it's page 33, footnote 10. The reason for showing you this is that it explains what I'm going to show you, which is it's really to deal with my Lord Justice Arnold's question about the electric kit. There was another electrical converter named the Electric Kit. Their website, it's the footnote at the bottom. The website was not in evidence, but you can see the kit fitted to a converted AGA on a third-party website, Westbrook Cookers and John Ray Stoves, and those are at supplemental bundle tab 10. And we'll be staying here just for a moment to look at some other ones. Tab 10, page 146. It's page 146. This AGA from 4,700, electric, gas, LPG or oil. The 2-oven AGA comes with 2-oven components. Compartments rather. And you've got different, there's 4 there.
On your copy, does the cookie notice lock at the top of the website as well?
Yes, the cookie notice, that's right, you're taking up
so we can't see the whole thing.
Yes. It looks like it should be very important information. And then page 131 is full picture of you can see the little electrical unit there. Westbrook Cookers. Convert your AGA range cooker to electric, start saving on bills immediately. Yes, that's right. So that links that with the footnote. And then there's Walter Dix. If you go to the beginning of this tab, there's just a picture of the electric kit panel in the bottom right. Now, just while we're in this tab, this is a tab of examples of reconditioned, refurbished AGA units. And my submission, there is a range of different ways that AGAs are referred to. They are sometimes referred to as yours, they're sometimes referred to as ours. But if you take, for example, just looking at this first one, Avec Cookers, 1.6, you can see there's the pictures of the colours. You can necessarily read the colour names, but it's quite common to offer those sorts of colour selections. The other thing about Avec Cookers is that they're also seller of the e-control unit. Pre-installed in an AGA. You can see on page 118. They refer to the e-control AGA. They refer to it as a controllable model, the e-control, and then at the bottom, the e-control AGA. And then variously over the page.
Sorry, can you just help me? Because that seems to be reading on from an earlier page, but I can't see where it reads on from.
Well, I had exactly the same question, but I understand this is from the same website.
Well, I'm not doubting it, but I'm wondering if something is missing or...
Starts at 114. Sorry.
I mean, it's obvious. Whatever's at 118 does not come immediately after, whatever one would say.
Yeah, I know. I can see what my lord's saying. You can see the
And the
little
reason
shopping-
why I'm asking the question is that this is actually quite suggestive, isn't it? Because, I mean, I appreciate your clients are not necessarily responsible for what AVEC do, but we seem to have a reference to something on electric AGA or the new generation controllable model, the e-control. And then but down below we have the e-control AGA. I mean, the consumer looking at that might well think that this is a model of AGA.
Yes, I mean, if AGA sold used or refurbished, that's the issue. I mean, as I've sought to emphasise, in a normal trademark case, that may be so, but where you are dealing with a situation where they're going to call these things AGAs because they are AGAs, and they're going to call the e-control unit e-control because that's what it is, and they are going to offer them to the public under an obligation to use both names.
And if we look on the following page, 119, I mean, again, the whole of the description has the flavour of this is a model of AGA. And by contrast with what we see at 120, the traditional always-on AGA.
It is an AGA. It's an AGA, my lord.
Is this a model of AGA?
It's a model of AGA.
Your case is that it is a model of AGA.
This is a model of AGA which has had a retrofitted electrical unit to it, which has been held not to impair the condition, whether it be mental or physical, of the goods. And there's nothing about that. I mean, in all cases, there is going to be at least some risk of a connection being formed, and that if the court is of the view, or takes the view that normal advertising, which mentions both brands in a compressed way, is going to lead to an assumption of commercial connection, where we say that's contrary to the reality of consumer understanding of the average consumer. I know that may be a controversial point, but we say that is clear on the findings of the fact by the judge, but also the correct finding on the basis of what the consumer must know. OEMs don't sell, Sony don't sell used televisions, and Apple don't sell used phones, and so on. It's just not.
You're placing a lot of emphasis on that, but it isn't at least subject to a, well, I can't see that it's subject to a finding of fact by the judge.
Well,
But the average consumer, whatever term you use, the person who would not gain the impression, you're stressing that they would know that AGA does not refurbish or deal.
Let me put it this way: the burden is on the claimant to establish that they don't. They are the ones that are in derogation of the exhaustion principle, seeking to trigger legitimate reasons. They are the ones that have to make the running on this. There is a default position, we say. Well, it does also depend on the goods. So, for example, let's say you were dealing with second-hand cars. People know that there's used approved Mercedes or BMWs or whatever. They know that. They don't know that about AGA.
Can you help me? Which ground of appeal is this? Because ground one is the judge applied the wrong test, and your point there is he applied porter cabin, and you say that's about outwards, and you say he should have applied BMW and Dior and Avora. So we've been over that.
Yes.
Ground two, judge applied the wrong approach, reached a rationally insupportable assessment of the facts in relation to the website and invoices. So is this point in support of ground two?
Comes in under both, because if he made an error of law, it entitles the court to reach its own view, to reassess the facts.
Well, that comes in not as a ground of appeal, but on reassessment. So
So
do I understand the way you put your case is if you establish either ground 1 or ground 2, so therefore this court is entitled to reconsider. This is a point you rely upon on
Yes.
reconsideration.
Yes.
Okay, that's clear.
Just to complete the picture of these additional, general reconditioners. Again, they are a fairly mixed bag. Some of them say your AGA range cooker. One of the first things is that all of them show pictures of the AGA, you know, in more or less the same way, attractively presented generally. They don't look particularly sort of second-hand. They possibly re-enameled, who knows. You've got, let me just find another, I don't want to go through all of them. If you look at page 129, you've got, this is a classic example. 129, you've got Elaine Stoves and Flues. So just like us, a completely different name is being attributable in answer to my Lord Justice Birss's question. Who are we? We are Elaine Stoves and Flues in this case. Reconditioned Argus Oakhampton, and then in the text below that, the penultimate line, to find out more about our Argus and cooking accessories. I mean, this is the danger of taking some small text and saying, well, you're attributing it to yourself. It's got to be looked at as a whole and with real world eyes, we say. Another example, Westbrook we were looking at just for the purposes of the electric kit. But if you see 131, the red number, our partly renovated products, partly renovated AGA range cookers available from stock. And it isn't, you know, traders trying to sell these cookers are not going to be, they know the market and the market knows them. If you look at these, advertisements, it's possible to think they all come from AGA, and the reason for that is because they are selling AGA products, and in respect of which their rights are exhausted. So there's an inherent propensity for this sort of connection to be made. That's a reason why you have to be very, very cautious when you approach matters with that in mind, because the ramifications of that on other traders could be very wide-ranging. Let me just show you one more example. Yes, 145. Again, this is the one we looked at earlier, but I just wanted to show you they just refer to the 2-oven deluxe AGA, the 2-oven traditional AGA, the 4-oven traditional AGA. I mean, how is this better than saying e-control AGA? I mean, we keep a large stock of AGA cookers in different styles and colours. It's as if putting a distinctive trademark, which the judge held was a distinctive trademark, makes matters worse, which can't be right.
Why can't it be right?
Well, because a distinctive trademark inherently is not something associated with AGA. So no consumer will have come across AGA selling second-hand goods. No consumer will have come across AGA being associated with the mark e-control. That's got to count for something in terms of what that can communicate to the consumer, especially a knowledgeable consumer, a sort of aficionado or at least an enthusiast. Let me just there are other e-control sellers, and I wanted to show you them. They come after the website we were looking at, and it's telling that they're a sort of mixed bag in terms of the way that they refer to e-control. So if I can show you, finish. Yes. Well, actually, while I'm here, I wanted to just double back on the invoices for 1 second. I was reminded to show you again, in answer to my Lord of Justice Birss's question, who are we, on the invoices, which are at tab 13 of the supplemental bundle. Who are we? We are e-control systems, made in UK Innovations Group Ltd. Very clearly marked, and all of the invoices in the big logo in the top right hand corner. We say no sensible view would regard the entity as being different because of the compressed nature of the language in an invoice listing. So if you go to the particulars of claim and the annexes of particulars of claim, that was core bundle 11, and it's the back of tab 11. I'll just work from the back, it's a bit easier.
Well, bear in mind you're now about 17 minutes into injury time.
I'm probably 2 minutes from being finished now. So 231, this is the other e-control sellers. So we've got 231, they refer to an e-control AGA, and at that's the same one, London Cookers at 227, e-control electric AGAs.
Is this a different e-control system?
No, it's the same.
So they're marketing these?
They're marketing, they're not necessarily adopting an identical formula. E-control electric AGAs, I mean, this is sort of, the way that these goods are marketed will vary slightly, and if one should not read too much into it. 215 is Westbrook Cookers again, and they refer to them as e-control Series X AGA or X Series AGA. And final one is 209, which I won't read out for your note. The final point, it will take me no more than a minute to say it, was this is a considered purchase. Mr. McGinley gave evidence to that effect. The judge said that there was something in the documents that he hadn't seen that confirmed that. He was provided with post-trial with some correspondence and emails, and rather than go through that, you can see that for yourselves at tab 12 of the supplemental bundle. There were emails, and in particular there's an email at 153 where Mr. McGinley's providing the electrical specification, the engineers ensuring the appliance, talking about the ampage of the condition. We could supply a fully renovated AGA fitted with Series 1. It's detailed transaction process. There is no prospect whatsoever when you look at the whole transaction that you are going to leave the transaction under the impression that you have been dealing with AGA. That is simply fanciful, my submission. There are other examples in that particular tab. Lords and Lady, I'm very sorry for taking up additional time, eating into the time of my learned friend. I hope that addressed you on all of the relevant principles. We say this case is an important case where, with a proper principled approach to the questions, this sort of very tenuous finding based upon a possibility that some connection might be is simply nowhere near enough to potentially find that has ramifications on competition and the consumer. So I can assist you further.
Thank you. Mr. Secretary.
My Lords, my Lady, I'm here on behalf of the respondents. The court's already been taken through parts of the judgment and the authorities, so I don't wish to spend too much time on that. But I think there are two headline issues that would be useful to address at the outset. And the first is what this case and appeal is and is not about. and the second is just to structure the wider aspects of the judgment, because I think that my learned friend hasn't fully addressed the picture. The appellant has tried to frame this appeal as some sort of David against Goliath battle, especially in the skeleton, where my client is trying to effectively obliterate the sale of electrically converted AGA cookers to divert customers to its own product. This case has nothing to do with that. My client has sued, the last time my client sued was in 2015. The reason that my client sued here was because of the way the appellant had refurbished, renovated, advertised, promoted and sold the e-control cookers. So my client regarded those as having far crossed the line, and the only issue so far as the court is concerned in terms of the appellant's appeal relates to trademark exhaustion and the narrow issue of whether there exist legitimate reasons for the respondent to oppose further dealings based on the way in which the appellant marketed and sold the e-control cookers. Now, the judge held that such legitimate reasons did exist. We say that he was correct to do so, but in any event, it was a finding that was plainly open to him on the evidence. And the court will also be alive to the fact that there is a respondent's notice in relation to the judge's findings of trademark infringement, and completely separate, there is a cross-appeal by the respondent in relation to the copyright aspects, which will be addressed tomorrow. So that's all the court needs to focus on. I don't intend to address any of the prejudicial remarks raised by my learned friend Skeleton beyond that. If I could turn to the structure of the judgment. So the judgment is in the core bundle at tab 9. And I appreciate you've seen parts of this already, so I'll skip over as much as I can. So picking that up at paragraph 11, there the court considered that there were a wide range of trademarks in issue. There were some word marks, a badge, a 2D line depiction of an AGA cooker, and a photograph. And those marks were alleged to have been infringed, of course, by the image shown under paragraph 4. And the important point, as the judge sets out in that paragraph, is that the, if I can call them e-control AGAs, retained their AGA badges. Externally, they looked the same as their AGA equivalents. The only difference is that in the place of the temperature gauge, which would normally be in the right-hand side, the respondent had fitted an e-control badge. So it's not surprising in my submission that the respondent alleged that the way in which the appellant had marketed and sold the e-control cookers infringed all of the respondent's trademarks. If I could then take the court to paragraphs 13 and 14 of the judgment. So there were 3 trademark infringement claims. The court's aware there was section 10.1, section 10.2, section 10.3, and the defendant had run a raft of defences which are set out at paragraph 14. And in my submission, those were bad points that were run. So the only one that the defendant was successful in is 14A, and that is the exhaustion defence. The second one is that the defendant had said that the AGA, in relation to the AGA word marks, that they had a defence under section 11.2b and or 11.2c. Now the court will be aware of the fact that section 11.2b and c require the use to be in accordance with honest practices. Now the judge held that that was not the case, because AGA was being used to identify the commercial origin of the goods, and the judge also held at paragraph 63 that such use was not in accordance with honest practices because the goods in question had been significantly altered by the fitting of an e-control system which had nothing to do with the respondent. There's no challenge by the appellant to that on appeal. Then if I could ask the court please just to read paragraph 14c. So in this paragraph, the defendant had taken a number of technical points in relation to the 2D AGA mark and was unsuccessful in that. And in relation to the 3D AGA mark and the 2D AGA mark, there was also a counterclaim for invalidity. which was dismissed. And again, there's no challenge to any of that on appeal. And the final point, so far as the trademark aspects are concerned, is that the appellant did take certain unpleaded points in relation to Section 10.3 on the basis that Section 10.3 requires reputation and specific harms, so unfair advantage, dilution, tarnishment. We were put to proof of reputation, and the latter were alleged not to have been met in this case. And if I could take the court please to paragraphs 80 and 81 of the judgment on page 125. So there the judge says, in my judgment, this evidence, which was unchallenged, clearly shows that the claimant had and has a very considerable reputation in relation to the AGA word marks, and it seems to me also in relation to the other marks. In the circumstances, it's understandable why in closing Mr. Mannich did not refer to the issue of reputation, whilst for the reasons I've set out above when dealing with the Section 12 defence, I do not think that the defendant's activities were detrimental to the repute of the marks. I'm satisfied that those activities were detrimental to and took unfair advantage of the distinctive character of those marks, and that they were without due cause. So what we have here is the appellant was held to infringe all of the trademarks. It had no defence under Section 11.2 on the basis that the use was not in accordance with honest practices. The judge expressly held that the appellant's activities were detrimental to the distinctive character of the respondent's marks and took unfair advantage of the distinctive character of the respondent's marks, and all of that was without due cause. In my submission, that clearly shows that the respondent was well justified in bringing the claim, and it also highlights that trademark exhaustion was the appellant's only surviving defence on the trademark aspects. Now turning to the appellant's appeal, I've structured things in the way that the appellant had structured them in the ground appeal and also in the skeleton. So the court's aware, of course, that there were two grounds. The first is broken down into sub-grounds. The ground one is that the judge applied the wrong test concerning commercial connection, and the first point is that it's alleged as a point of law that the judge applied the wrong test because he applied a test from Portakabin relating to keyword advertising, which is not applicable. The second is what I understand to be an alleged error of principle, in that the judge allegedly applied the wrong balancing exercise or applied the test at the wrong point. The third is also what I understand to be an alleged error of principle, is that the judge allegedly failed to apply the whole of the correct test or to properly apply it. And the fourth is specific points in relation to BMW and Dior, which are probably also advanced as an error of principle, although I'm not clear on that at this stage. So on the alleged imposition of the test, of course the court's aware that under Section 12, trademark rights are exhausted unless there exist legitimate reasons. Section 12.2 is a derogation. The authorities show that as per the wording of Section 12.2, one example is where the condition of the goods has been changed, but there are other examples relating to serious damage to the reputation of the marks, or the one that is relevant in this case is where there's some sort of commercial connection between, in this case, the appellant and the respondent. Now, the appellant had spent a long time in its skeleton and orally, essentially arguing that the judge had applied the wrong difficulty in telling test when it's only applicable to Google AdWords cases. And there's nothing to that point. The judge set out in his judgment in two places the relevant test on commercial connection, and the court's been taken to it already, but it's central to the appeal, so I wish to take the court to it again. And so it's paragraph 22 of the judgment. And in this paragraph, the judge says, as set out in Section 12.2, one example of a case where proprietor might have legitimate reasons to oppose is where the condition of the goods has been changed or impaired. Other examples are where the further dealings might seriously damage the reputation of the mark, and then relevantly, or give the impression that there is a commercial connection between the person responsible for those dealings and the trademark proprietor. And in support, the judge cites the BMW and DNET case at 51 and the Portakabin case at paragraphs 80 and 92. Then if I could ask the court to turn to paragraph 48. So this is the other paragraph where the judge sets out the test on commercial connection by reference to the authorities. And in paragraph 48, in order to establish that there is a requisite commercial connection, the claimant must show that the defendant's activities were such that normally informed and reasonably attentive customers would be able only with difficulty to ascertain whether the goods in question originate from the claimant or from an undertaking linked to it, or contrary, originate from a third party. And in that paragraph, the judge refers to the Portakabin case again, but this time at paragraphs 80 and 81. So there's the addition of paragraph 81, and he also refers to Viking Gas at paragraph 40. Now, I appreciate that you've already been taken to those authorities, but obviously as the respondent to the appeal, there are further or additional points that I would wish to make. So I'll address the points in context as succinctly as I can. Turning first to the BMW judgment, which is in the authorities bundle at tab 9. I can skip over the background facts and the referred questions. The court's familiar with that. So picking up at paragraph 51. This is one of the paragraphs that the judge cited, and it says the fact that the trademark is used in a reseller's advertising in such a way that it may give rise to the impression that there is a commercial connection may constitute a legitimate reason. So it's a very short point. The judge clearly shows that he had in mind and cited the correct test, which is that there is a commercial connection. And in fact, in the next...
May give rise to the impression that there is a commercial connection. So I assume you would emphasise the word may as well as the word is.
I emphasise that there is a commercial connection. And then in paragraph 53, the CJU goes on to say that, in fact, it's only if there, on the other hand, there is no risk that the public will be led to believe that there is a commercial connection. So again, we say that that underlines the point. And the CJU goes on to say that the reason why that is acceptable is because in those circumstances, a reseller who effectively could only communicate their wares by using the proprietor's mark is entitled to informative use, as such use is necessary to guarantee the right of resale. And an important point which has already been touched on, as the CJU says in paragraph 55, is that whether advertising may create the impression that there is a commercial connection is a question of fact. So if the judge applied the law correctly, as we say of course he did, it's not a promising basis for the appellant's appeal, which then requires the appellant to challenge the judge's findings of primary facts. The other case that the judge cited in the judgment is Portakabin. If I could take the court to that, that's tab 11 of the Joint Authorities bundle. I will mention a little bit about the background here because, my learned friend, there was some ambiguity over the scope of the judgment. So if I could ask the court to pick that up, please, at paragraph 16. And the infringement allegations in that case concerned Google's paid AdWords referencing service, which allows companies to reserve keywords so that when a user searches for a particular term or terms, an advertising link pops up. And for that AdWords referencing service, Portakabin had chosen a number of keywords, variations of which were chosen in case consumers effectively mistyped the words so that the relevant advert would show up. And then if I could ask the court to just read the first and third referred questions on page 171. I think my Lord Justice Arnold already flagged the context, but if you could just refresh your memory, please, of those. So the language is a little bit cryptic, but effectively there were two aspects. There were the keyword infringement aspects, and if infringement was established, whether exhaustion applied. And some of the other questions also went to the infringement aspects, which the CJU addressed compendiously from paragraphs 23 onwards. So at paragraph 26, the court noted that the double identity provision requires the use complained of to adversely affect or be liable to affect the functions of the trademark. Then at 31, as regards the use of signs identical with trademarks as keywords for referencing service, the court held at paragraph 81 of Google France that the relevant functions to be examined are the function of indicating origin and the function of advertising. And then importantly, at paragraph 34, as regards the function of indicating origin, that will be adversely affected if the ad does not enable normally informed and reasonably attentive internet users, or enables them only with difficulty to ascertain whether the goods or services referred to come from the proprietor or an undertaking economically linked to it. And the reference for that is Google France. My learned friend referred to that as the so-called Google France transparency test, and it is a test that applies in the context of keyword advertising, which is how it originated, but it hasn't been misapplied by the judge in this case. So the CJU went on to say that that's a question of fact for the referring court to determine. Then moving forward to paragraph 75, at paragraph 75, the CJU noted that at the outset, as is apparent from the order for reference, Rangemaster's advertising carried out with the assistance of keywords identical with or similar to Portakabin's trademarks concerns to a large degree the resale of used mobile buildings. It's also common ground that those goods have been placed on the market by Portakabin under the trademark Portakabin. And in the subsequent paragraphs, the CJU went on to make the point that the further commercialisation of the goods can only be opposed, of course, where there are legitimate reasons. And then at paragraph 80, which is the paragraph that the judge had cited in his judgment and which the court has seen, and that paragraph expressly refers to the fact that there is a commercial connection. So again, we have the judge correctly citing the paragraph that correctly refers to the legal test. And the judge also cited paragraph 81, which the court has been taken to, but if I could just ask the court to refresh your memory of that paragraph. Now, this paragraph does use the language of Google France, and this is given in the context of a keyword advertising case. But in effect, all the CJU is saying in paragraph 81 is that if an advertiser uses keywords that fall on the wrong side of the difficulty in telling test, then that necessarily corresponds to a situation where there is a commercial connection between the parties. So the appellant accepts that Portakabin at paragraph 80 sets out the correct legal test, but then takes issue with the next paragraph, but it's clear that the CJU in Portakabin is treating the difficulty in telling tests as being relevant to exhaustion cases and not as being limited to AdWord cases. And further, the judge also cited paragraph...
Just a second, Mr. Salmi. You said something a second ago, which we say so. When I heard it, I thought, yes, that sounds right. And now you're saying something slightly different. And I just want to go back, if just one sentence, if I may. What I think you said about paragraph 81 was that what the CJU were doing was taking a case in which, in a keywords advertising case, the difficulty of telling test was satisfied, and then saying that if in a keywords advertising case, the difficulty of telling test is satisfied, that would also mean you don't get a defence under the exhaustion principle.
That's my understanding. That is what they've said. So effectively,
okay. Taking that, and if I may say so, that at least first blush does seem to be what paragraph 81 says. Doesn't that mean that it is not an approach? It isn't anything to do with the facts of this case.
So I think it's fair to say that the language from Google France and the language that's applied in the Portakabin case is in the context of keyword advertising. But since if you're on the wrong side of the difficulty in telling test and there is a commercial connection, then effectively they're the same thing. So whilst it in practice doesn't apply to the facts of this case, in my submission, the fact that the judge referred to the appropriate test from paragraph 80 and the fact that he then recited the language from Google France in 81 shows that he had the correct test in mind in both cases.
Okay.
The other point is
Sorry, are you? Does that mean to say the correct focus is paragraph 80, which the judge went on to apply?
the correct focus is paragraph 80.
In the event that although you're not accepting this, I think that there might be a difference between that and the difficulty in telling.
I think that's exactly right.
Yeah.
So I'd say the
So
appropriate
you're
test is
saying they're
paragraph
broadly
80.
the same, but the judge applied the test. In case I'm wrong, the judge applied the test at 80. Is that correct?
Yes, the judge applied the test at 80, and he also cited paragraph 92 of Portakabin, and there the CJU goes on to make the point that unless there is a legitimate reason within the meaning of Article 72, which justifies him opposing that advertising, such as use of that sign, which gives the impression that the trademark proprietor are economically linked. So
Did you say the judge referred to 92?
he
In
also
paragraph
refers to-
22 he did.
I thought it was 91.
If you go back to 22 of the judgment, he cites 80 and 92, albeit later it's 80 and 81.
Oh, I see.
So
Yes, thank you.
the combined ones are paragraphs 80, 81 and 92. In view of that, I don't think it's necessary to say anything else about keyword advertising cases, and I think that that's really just a distraction from what this appeal is about in context. The third and final case that the judge cited in his judgment in the context of commercial connection is Viking Gas. Now that's at tab 12 of the Joint Authorities bundle. That case concerned Viking Gas's business of refilling Coast Gas's three-dimensional trademarked gas canisters and whether Coast Gas's rights in those bottles were exhausted. Now the case features heavily in the context of some of the appellant's other grounds, but I just want to flag the point in relation to Article 7.2 here, and will address other aspects in context later. So at paragraph 35 on page 207, in this paragraph the CJU made the point that the sale of Coast Gas's composite gas bottles exhausted the trademark rights, so the purchaser was free to have the bottle refilled not only by Coast Gas but also by competitors. However, as the final sentence of paragraph 35 says, the corollary of that right on the part of the purchaser is the right of those competitors within the limits set out in Article 7.2 to refill and exchange the empty bottles. And then the CJU went on to say, at paragraph 37 over the page, that the court has therefore already held that such a legitimate reason also exists when the use by a third party of a sign identical with or similar to a trademark seriously damages the reputation of that mark, or when that use is carried out in such a way as to give the impression that there is a commercial connection. A further important point to note is that paragraph 38, the CJU again explicitly stated that the assessment of commercial connection is a question of fact, which again doesn't bode well for the appellant's appeal. Then at paragraph 40, which is the paragraph that the judge cited in respect of the relevant test, the labelling of the composite bottles.
He also cited 37.
He cited 37 as well, and paragraph 40, which expressly says, must not lead the average consumer, who is reasonably well informed and reasonably observant and circumspect, to consider that there is a connection between the two undertakings at issue. So the judge cited the very test from Viking Gas on which the appellant relies. And then, as I mentioned, the CGU went on to make some specific points on the facts of that case, and that's important for the referring court's consideration as to when or whether there is a commercial connection. But in my submission, the short point is that the judge correctly cited the relevant authorities, and the first part of the appellant's ground 1 does not identify any error of law.
Well, can I ask you this question? I mean, one take on the Court of Justice's case law is that in the keyword advertising context, the test that's propounded is tantamount to a reverse likelihood of confusion test. In other words, it is in substance a likelihood of confusion, but it puts the onus the other way around. So you have to show that there's, as it were, no sufficient likelihood of confusion. Whereas the test that seems to be applied not only in traditional likelihood of confusion cases, but also in the other cases concerned with exhaustion, and we see this particularly in BMW and DNIC, we see it in Deal and Evora, we see it in Viking Gas, is an affirmative likelihood of confusion test, as it were. So, in other words, to put it in common law terms, it's a reversal of the burden of proof. And it therefore might be said that there's, at any rate, an ambiguity in the judge's judgment as to where he puts the burden of proof. What would you say to that?
I think that's a very fair point in the sense that really the references should be to a commercial connection. The reference to paragraph 81 of Porter Cabin and the express citation of the language from Google France potentially on its face would appear to raise some ambiguity, but when we look at the authorities, it's clear that it makes no difference on the facts, but also the way that the judge applied the test. When you look at the judgment, is clearly he had in mind and applied a test of commercial connection. I can make that point good by reference to the judgment. If I could ask the court to return to the judgment in the core bundle at tab 9. And it's paragraph 54 on page 119. So here the judge says, ultimately, if the defendants wished to sell these converter cookers, there was a need for them to ensure that customers were not given the impression that the conversion was somehow connected to the claimant, and even as suggested by the CJU and Bristol-Myers, to take steps to dispel such an impression, as set out above. The website and invoices did the opposite. And then at paragraph 60, under the heading Conclusion on section 12,
Well, sorry, can I just tease out what I think you're saying there? So I think, if I've understood you correctly, what you're saying is the first sentence might be thought to be applying a reversed burden of proof, but when you look at the last sentence, what you're saying is the finding is actually they did the opposite, therefore it does give rise to the wrong impression, and therefore that is applying the correct standard of proof, or the correct burden of proof. Is that?
My Lord, I would say that the first sentence is not giving the impression of the wrong burden. We get that really from the Porter Cabin language in the judgment. Reading paragraph 54, in my submission, it's clear that the reference to "were not given the impression that the conversion was somehow connected" is a reference to the correct test of commercial connection. But then, as my Lord said, the judge goes on to positively affirm. So whilst I would not accept that there's any ambiguity with reference to the first part, it's completely clear from the paragraph as a whole.
Well, surely you also need to read it with 52 and 53. 52, first sentence, likely to give customers the impression, and halfway down 53, reinforced the impression that there was a commercial connection.
That's not, my lady, there are other paragraphs.
Well, yeah, I'm just observing. I wouldn't myself start at 54. To understand what the judges say.
I'll take the court to those paragraphs when addressing ground 2, which is the appeal on the facts, because they arise in the context of the judge's assessment of the website and the invoice.
My lady's question was designed to help
you.
because if you read it in the way that she says, or suggests, I apologise, ways that she was suggesting, is that would indicate that he was applying the correct test consistent with your submission.
My lady, I'm grateful. It is my position, certainly, that the judge was applying the correct test. I fastened on to paragraphs 54 and also paragraph 60, because those were two paragraphs that the judge himself had fastened on when saying that whatever the test, he had applied the test of commercial connection in any event when refusing permission to appeal. And I think at paragraph 60 we have again the reference to the impression that there is a commercial connection. Now, for completeness, I should mention that my Lord Justice Arnold had raised another gas refilling case, which is Soda Club, and that was a case that was cited to the judge by the appellant, that's not mentioned in his judgment. It's not assimilated law. The appellant's position was that it's the latest case and said the same as previous CJU authorities. The respondent's position was that it was persuasive and did not add anything. I don't think I need to take the court to that. The Soda Club simply reiterates the commercial connection test and notes that whether there is a commercial connection is a question of fact for the referring court. So again, in that case, the CJU also gave some guidance on the point in the context of that particular gas refilling case, which I'll consider under the appellant's other limbs of appeal. But in my submission, the judge cannot be faulted for not having cited Soda Club, since it's not assimilated law, and in any event, just reiterates the legal test that he correctly had in mind and did apply. The next point to respond to is the appellant's contention that the judge applied the wrong balancing exercise or applied the balancing exercise at the wrong point. And I think this point can be disposed of quickly. Viking Gas, as my learned friend accepted orally, explains that the engagement of the exhaustion principle, so not the engagement of section 12.2, the engagement of the exhaustion principle involves a balancing exercise. And the point from that case is that Kosan Gas, the trademark licensee, had argued that exhaustion only prohibited the further commercialisation of the bottles filled with original gas or empty bottles, and that it did not authorise third parties to fill the bottles with their own gas. The CJU noted that the composite bottles were intended for reuse a number of times. They were not merely packaging, but had an independent economic value. So against that background, the CJU said at paragraph 31, and if I could just quote from the judgment without taking the court to it, in those circumstances, a balance must be struck between, on the one hand, the legitimate interest on the part of the licensee of the right to the trademark constituted by the shape of the bottle and the propriety of the marks affixed to that bottle, and on the other hand, the legitimate interest of purchasers of those bottles, in particular, the interest in fully enjoying their property rights in the bottles. So the CJU went on to say that the sale of composite bottles allowed Kosan Gas to realise the economic value of the marks relating to the bottles, and purchasers would not be able to fully enjoy their property rights in the bottles if they were restricted downstream, also because that would unduly affect competition. So the CGU held that the sale of the composite gas bottles exhausted Cosan Gas's trademark rights, and it also gave purchasers and competitors the rights to refill those bottles. But the important point is that that was subject to Article 7.2. So the balancing exercise in that case applied to the engagement of the exhaustion principle. But in this case, the appellant accepted that the AGA cookers were put on the market by the respondent and that the respondent's trademarks were exhausted, subject to the operation of Section 12.2. There's no balance of the type contemplated by the CJU in Viking Gas in determining whether the respondent's rights were exhausted at all. So the threshold question of exhaustion doesn't arise, and this ground of appeal does not arise either. The appellant's third subground, under its first ground of appeal, is that the judge allegedly failed to apply the whole of the correct test or to properly apply it. I've already addressed the court on why the judge had in mind the correct test on commercial connection, but since this subground involves consideration of the judge's balancing exercise and is therefore a challenge to a multifactorial evaluation, it can only be interfered with if the judge erred in principle. And I think it would be appropriate to take the court to 2 paragraphs in the judgment where the judge expressly refers to the balancing exercise. So the first is at paragraph 24. And in this paragraph, the judge says, in my judgment, in determining whether a case falls within Section 12.2, the court must strike a fair balance between protecting the trademark proprietor's interest in a trademark that has been applied to goods and protecting the interests of others, such as the original purchaser. On this basis, the claimant readily accepts that people are entitled to refurbish and to sell second-hand AGA cookers using the AGA name. However, the defendant's actions fell on the wrong side, and in particular the last few lines, and also that the way in which the e-control cookers were marketed and sold might lead people to believe that there was a commercial connection between the defendant and the claimant. On this basis, it argues that it has legitimate reasons. So we see reference in this paragraph to the balancing exercise. And then turning next to paragraph 52, which is, I think, one of the paragraphs that my lady had flagged. Again, the judge refers, in my judgment, these statements taken as a whole were likely to give customers the impression of what they were being offered as an AGA product, and this was something about which the claimant could complain. And then again, in that paragraph, there are references to taking the statements as a whole, and the final sentence, in my judgment, in this context, the interests of the claimant as a trademark proprietor outweigh the interests of people, such as the defendants dealing with the cookers in the aftermarket. So, in my respectful submission, those paragraphs show that not only did the judge have in mind the correct legal test, but he applied it. He had in mind the balancing exercise, the evaluative exercise, and he applied it. I should briefly address some of the points raised by the appellant under this head. So, as I mentioned, in both of the gas filling cases, the CJU set out the commercial connection test and then went on to give specific guidance. Now, there's a limit to how far you can take that guidance. As my Lord Justice Birss pointed out, the guidance is given to the referring court in respect of the facts of that particular case. But generalising, because the appellant's generalised, there are a few points that the appellant says apply by analogy here. The first is that in assessing whether there is a commercial connection, it's necessary to take into account the practices of the sector, and in particular whether consumers are accustomed to the gas bottles being filled by other dealers. Now, there's no error of principle here. I took the court to paragraph 24 of the judgment, which makes it clear that the judge had in mind the interests of the parties. Further, at paragraph 35 of the judgment, I don't think I need to take the court to it, the judge expressly referred to there being a reasonably extensive market in the sale of refurbished AGA cookers and referred to some examples in a footnote. Then at paragraph 39, the judge accepted the legitimacy of converting fossil fuel AGA cookers to electricity. Now, the fact of the matter is that there is a legitimate secondary market for refurbished AGA cookers, but there's no custom or practice of using e-control AGA. The appellant came up with that term with the introduction of its e-control cookers in 2021 and was promptly sued for it. So the alleged trade practices in the sector point doesn't assist the appellant. Now, in its skeleton argument at 34, and I don't think I need to turn to it, the appellant said that even other electrical converters made extensive use of the AGA trademark and also referred to their wares as e-control AGAs. And then the appellant refers by way of a footnote to a number of examples that appeared at trial. The court was taken to these, but I want to briefly take the court back to this. So if I could ask the court to turn to the supplementary bundle, tab 10. And it's page 113. There are over 30 pages in this tab of third-party refurbishers, and in fact there was other material that was exhibited at trial. The appellant has chosen not to include that material, has chosen to include this, so we can assume that the appellant regards this as the best case. There is only one single example which the court was taken to of a company called J. Westaway using e-control AGA on pages 118 and 119. So the material doesn't support the appellant because there's no trade practice of using e-control AGA in the way that the appellant contends.
But sorry, that, as I understood it, that is the appellant's product.
This is the appellant's product, and it's being sold
by another person.
By another company called J. Westaway. There's a single example, but of course, as the judge had also said, I think in the permission to appeal judgment, if other people are doing something that's found to infringe, then they too are likely to be infringing. You can't use that to circumvent infringement. In any event, I should make the point that there was cross-examination on this material at trial, and there's no basis for the appellant to ask the Court of Appeal to island hop when reviewing the evidence in this way. The second point that the CJU raised in the gas filling cases is that if consumers go directly to Viking Gas to refill a bottle, they're more readily in a position to be aware that there's no connection between Viking Gas and Kosan Gas. And by analogy, the appellant contends that if consumers are dealing with it rather than the respondent, they should prima facie understand that there's no connection between the parties. Now, of course, consumers knew that they were dealing with the appellant. The issue was that they were being given the mistaken impression that what the appellant was offering was a conversion connected with the respondent. The judgment took into account the marketing of the e-control cookers, the way they referred to the invoices. There was no evidence correcting any mistaken impression. So the fact that consumers know that they're dealing with the appellant is a point that doesn't go anywhere. Now, in its skeleton argument, the appellant had raised a number of other points which were not pursued orally. For example, that the judge had failed to take account of the fact that the respondent had already realised a profit, that the judge failed to consider the interests of customers. I think these were all adequately addressed in my skeleton argument at paragraphs 40 to 45, and there's little more that I can usefully add orally. However, I think it would be worth taking the court to the judge's judgment refusing permission to appeal on analogous points, since his dismissal of those points is, in my submission, tightly reasoned. So this is in the core bundle at tab 10. Page 138. And if I could ask the court, please, to turn to paragraph 17 on page 142 and just read, please, from paragraph 17 to 23. because there are a number of points that are addressed efficiently in those paragraphs. So in my submission, those points are also easily disposed of. The final point to respond to in respect of the appellant's ground 1 is the reference to the rights of resellers in the BMW and Dina case and Christian Dior. The appellant's argument is that the mere fact that a reseller derives an advantage from using a mark that's otherwise honest and fair does not give the proprietor legitimate reasons to object to such use. The use under section 1112 was shown not to be in accordance with honest practices, but in any event, the appellant has referred to partial extracts from BMW and DNEC and also from Dior, which do not advance the position or the appellant's appeal. So if I can take the court back to the BMW case in the authorities bundle at tab 9. And if you could turn to paragraph 53, please. In the appellant's skeleton, the appellant had partially cited from paragraphs 53 to 54, but it omitted the crucial words which I had mentioned at the start of paragraph 53. If, on the other hand, there is no risk that the public will be led to believe that there is a commercial connection between the reseller and the trademark proprietor, the mere fact that the reseller derives an advantage does not constitute a legitimate reason. So clearly a reseller can be entitled to use a mark when reselling goods that had been placed on the market under that mark. Here the appellant could have stated that it was selling AGA cookers that it had refurbished and that it had fit with the e-control system, but it didn't need to market them in the way that it had done as e-control cookers. So the BMW authority does not support the appellant, and the appellant had also cited a passage from Christian Dior. I don't think I need to take the court to it, but the relevant paragraph is paragraph 38, where the CJU said, when trademark goods have been put on the community market by the proprietor of the trademark or with his consent, a reseller, besides being free to resell those goods, is also free to make use of the trademark in order to bring to the public's attention the further commercialization of those goods. That paragraph has nothing to do with the derogations from exhaustion. So the conclusion in respect of those points is that the judgment does not interfere with the rights of resellers, and nor is it contrary to both BMW and Dior. I can address the court on the appellant's ground 2 briefly. This ground relates to the judge's particular assessment of the websites and invoices, and his finding that they were likely to give customers the mistaken impression of a commercial connection. The appellant says this is rationally insupportable in light of the evidence. I don't think I need to take the court to the website and invoices because you've been taken to them recently. But if I can take my lords and my lady to the relevant parts of the judgment instead. Again, it's in the core bundle at tab 9. And picking that up at paragraph 50 on page 118. So in that paragraph, the judge sets out the extracts from the website, which my learned friend took the court to. Then at paragraph 51 and 52, in effect, the website was offering customers the opportunity to buy an eControl AGA as pictured with a warranty, and it seems available in one of a range of colours, and an opportunity to convert an existing AGA cooker using the eControl system. And then at paragraph 52, in my judgment, these statements taken as a whole were likely to give customers the impression that what they were being offered was an AGA product, and this was something about which the claimant could legitimately complain. The final sentence, taking the statements as a whole, I find that the reference to the eControl system were likely to be taken as references to a system that was connected with the claimant, certainly in the absence of any statement making clear that what was an offer was not derived from or connected with the claimant. And then if I could just ask the court, please, to read paragraphs 53 and 54. Now, if I could just pick up 2 points on paragraph 53. The first is my learned friend's submission that AGA does not sell renovated cookers. Consumers are aware of that. There's no evidence on that at all. There's nowhere does that appear in the judgment, and in fact in paragraph 53 I make this finding notwithstanding Mr. McGinley's evidence that customers buying an eControl cooker were making a considered and relatively expensive purchase and would have extensive discussions from which they would have known that they were being offered a refurbished second-hand AGA cooker. The other point from paragraph...
Sorry, where were you reading from there?
Paragraph 53, the first few sentences. And the other point is that in paragraph 53, the judge goes on to say, in the first place, although Mr. McGinley claimed that such discussions were evidenced in the disclosed documentation, I was not taken to any document that clearly corrected the impression created by the website. So, relating to the latter point, in its skeleton argument, the appellant refers to the fact that it asked the judge to provide such evidence references, identifying documents that it says corrected the mistaken impression. And that was done after trial. I don't need to take the court to those, but for your note, those are in the supplementary bundle, tab 12, on page 150. And the short point, as the judge said in his judgment when refusing permission to appeal, at paragraph 16, and again there's no need to turn to that, is whilst those references show that people knew they were dealing with the appellant, which is not an issue, none of them served to correct the impression that the eControl system that the appellant was offering was connected with the respondent. And for the court's reference, the citation I just gave is from the PTA judgment in the core bundle, tab 10, page 142. So for those reasons, the appellant's ground 2 does not come close to showing that the judge's assessment of the evidence was rationally insupportable, and in my submission it should be dismissed. Now, turning finally to the respondent's notice, this relates to paragraphs 55 to 59 of the judgment. And if I could please ask the court just to turn to those paragraphs. In those paragraphs, the judge considers the extent to which post-sale confusion might be relevant to the analysis. And he notes that this was a subject of further submissions from the court, from the parties after the draft judgment was circulated. And this court will be very familiar with the concept of post-sale confusion. My Lords, Lord Justice Arnold and Lord Justice Birss heard iconics in the Court of Appeal, and my Lady Justice Falk was the trial judge in Breguet and Samson, where post-sale confusion was argued and succeeded on its facts. The legal point is a simple one, as a citation from Breguet and Samson that shows at the top of page 120. It's well established in both EU and domestic case law that it can be relevant to take the post-sale context into account when considering trademark issues. This point was recently affirmed by the Supreme Court in Connex. And if I could just take the court to that, it's in the authorities bundle at tab 18. And picking that up, please, at paragraph 67. On page 379 of my authorities bundle. Now, as set out at the top of that paragraph, one of the questions on appeal to the Supreme Court was whether, when assessing whether there was a likelihood of confusion under section 10.2, that could include the risk of confusion arising outside of the transactional context and or by someone other than the potential purchaser. The conclusion to that question is set out by the Supreme Court at paragraph 86, where they approve my Lord Justice Arnold's statement that it is possible in an appropriate case for use for sign to give rise to a likelihood of confusion as a result of post-sale confusion. And then go on to say, we reject Greenpeace's submission that only post-sale confusion affecting or jeopardising the essential function of a trademark as a guarantee of origin at the point of a subsequent sale or in a subsequent transactional context can amount to actionable infringement. We also reject Greenpeace's submission that before there is an actionable infringement post-sale, confusion must result in damage at the point of sale or in a transactional context in the sense of influencing consumers when they make a choice with respect to the goods or services in question. So essentially, a sign can give rise to confusion as a result of post-sale confusion, even if there is no likelihood of confusion at the point of sale, and there doesn't need to be any impact on consumer purchasing behaviour, for example, in relation to a subsequent sale or a subsequent transactional context. On that basis, the respondent had argued at trial that third parties coming across the e-control cookers in the wild would see AGA and would see the e-control badge and would assume that the e-control cookers were co-branded AGA cookers, and in effect that consumers would think that there was a commercial connection when looking at the cookers. If I could return to the core bundle and see how the judge addressed this. So again, it's tab 9 of the core bundle, and it's from paragraphs 56 onwards. So that at paragraph 56, the judge just reiterates the point that I mentioned. And then if I can ask the court, please just to read paragraph 58. Now, with all due respect to the judge, the respondent says that the judge's reasoning at paragraph 58 is wrong for the following reasons. First, as Mr. McGinley had accepted, consumers seeing a co-branded e-control AGA cooker could be confused. As a matter of law, it does not matter whether that is later dispelled. Second, it also does not matter whether that is particularly likely or not. In Breguet and Samsung, my Lord Justice Arnold had made the point that the fact that consumers might see the dial branding on Samsung smartwatch and think that it reflected the origin of the watch, that's enough. It doesn't matter that it's a relatively infrequent occurrence. My Lord Justice Arnold has said the fact that it may be a relatively infrequent occurrence is neither here nor there. Third, it should have made no difference to the judge's assessment that the e-control badge was positioned separately from the AGA badge, because it was already common ground that consumers could be confused, so those points did not undermine the respondent's arguments. And for those reasons, the respondent contends that the judge should have held that the way that the appellant had marketed and sold the e-control cookers was objectionable, and so too was the co-branded e-control cookers themselves.
Could I ask you this question? I take the points you make about the reasoning, but if one compares with the reasoning in relation to the marketing, as my Lord Justice Birss put to Mr. Malledge this morning, the point that the judge regarded as being key in the context of the marketing was the composite expression, e-control AGA or AGA e-control. And isn't the nub of the point here that you don't have that composite expression, rather you've got the two signs being used separately?
I think, my Lord,
side by side, as it were, on the same product.
I think my Lord is right that that is exactly the key point of difference. But in my submission, that point of difference doesn't matter in circumstances where it was accepted that consumers seeing it could be confused. So whilst in principle, I mean, if it was very far apart or on the back and there was no potential for confusion, then I could see why it might matter. But on these facts, it should have made no difference. Before concluding my submissions on the respondent's notice, it's apposite to note that the judge had originally found in the respondent's favour on post-sale confusion, and the relevant paragraphs were amended after further submissions from the appellant, which was sent to the judge only a few hours before hand-down. And if I could
how does this help? Because I mean, it's the judge's final conclusion that matters, particularly having regard to correct appreciation of the law.
It's not a point of prejudice at all. I wanted to take the court to the judgment before it was amended, just for the my submission, the cogency of the reasoning.
All right, so what you're going to say is he was right first time and wrong the second.
In that case, my Lord, maybe.
All right, let's have
say 5 minutes.
Go on.
It's in the supplementary bundle at tab 1. And it's paragraphs 52 and 53. And if I could just ask the court, please, to read those paragraphs. So, my Lord, my Lady, I would adopt the short form phrase to say that the judge was right the first time and he was wrong the second time. In fact, we would simply note that the judge's original reasoning in relation to post-sale confusion is consistent with his findings in relation to the website and the invoices. And in my submission, there's no principled reason for distinguishing between them. So for those reasons, we submit that he was correct initially, and we would effectively ask the Court of Appeal to reaffirm that initial assessment. My Lords, my Lady, unless there are any further questions, I don't have any further submissions.
No, thank you. Very good use of time. Well done. Mr. Malledge.
My Lord, just to pick up on the last point, the rejection of the submissions that were made about the distinction between the appearance of the cooker and the appearance of the website, they work for us too, in the sense that we make the same point. That's an internal difference between the judge's two findings, and he ought to have found that the website didn't infringe for exactly the same reason that he found that the cooker didn't. Because if one thinks about it, the reason why the website said what it said was because it referred to the two signs on the front of the cooker, referentially. But a far more fundamental point that I wanted to address in my learned friend's submissions, because I think it goes to my appeal, is this. My learned friend, unless I misheard him, I took him to be accepting, or at least notionally accepting the possibility that people knew who they were dealing with when they were dealing with my client. And he got around that by saying it didn't matter because the product that I was dealing with would be linked to AGA. If those are the facts, that does not satisfy. This is not a trademark infringement case. This is an exhaustion, legitimate reasons case. That is not sufficient to satisfy.
Why not?
Because
it's a commercial connection.
The commercial connection must be between the two parties. It must be that they are connected parties. It's not that they happen to be selling the same goods. That he's accepting that.
No. His argument, as I understood it, was yes, they know they're dealing with you, but nevertheless, they're given the impression that there's a commercial connection.
They must. The judge's finding was that we are selling AGA products. We are part of the AGA organisation, effectively. Otherwise,
where does he make that finding, as you put it?
That's when he's dealing with the sub-brands. I mean, otherwise, what is the connection? I mean, that's the issue I have. The test under European law for commercial is there must be a commercial connection, just in terms of a convenient place to find the test. Remind ourselves of it. 44 of SodaStream. The requirement is that consumers get a false impression which may arise in the mind of the consumer as to whether there's an economic connection between the trademark proprietor and a reseller. So an economic connection. If I've bought goods off somebody, or I'm selling goods that happen to be linked to AGA, but I'm nothing to do with AGA, how does that satisfy the test?
Well, it satisfies the test because what the judge found, as I understand it, in 52, for example, was that it was the e-control system was likely to be taken as reference to a system that was connected with the claimant. And that's not right.
But if it's connected, that's not a problem, as long as it's not connected with the defendant.
But the e-control system isn't connected with the claimant.
But that's not connected. That's my point. I hope I'm completely understanding. That is not connecting the defendant to the claimant.
Well, it is, because it's your system. The e-control system is your system. But what you're doing is making people think it's AGA's system.
But there must
That's
be
a connection between you and AGA which doesn't exist.
The false impression must be that me and AGA are connected.
Right.
Right.
And
So
you are the e-control system.
But if people know who I, this is the part I'm trying to get my head around.
You are. You're not the system. You are the people doing the e-control system.
But
Of
if
course.
they,
You are, aren't you?
but if they know that I'm the person doing the e-control system, then they know it belongs to me, not AGA.
No, but the judge found that the references were likely to be taken as references that the e-control system was connected with the claimant.
Right. That's the judge's finding there.
Yes.
But that's
Which is
not
what Mr. Selby was referring us to.
I took him to be saying that the product was associated, but they knew who they were dealing with. They knew that we had nothing to do. We were not linked to the claimant.
No, he didn't accept that.
No.
That's a different point.
Well, the part I'm struggling with, my lords, is what is the nature, sorry to ask the question forensically, but what I'm struggling with is, I say it more to my learned friends, what is the nature of the link? This is not substituting.
Why does it matter? That would be the question I would put to you. It is sufficient for there to be a misapprehension, either that there is a connection at the level of the undertakings, or that there is a connection at the level of the goods. It's immaterial.
And in terms of the connection at the level of the goods, that one is the manufacturer and the other one, in reality, is
Well, it doesn't matter whether it's as manufacturer or in some other trade connection, but let's take manufacturer as the paradigm example. If consumers are given the impression that you are the manufacturer, that AGA is the manufacturer, contrary to the fact, why is that not sufficient?
because they're not connecting the two companies, they're not mixing up the two companies one for the other. I think what I'm getting at is they must be linked at the level of undertakings.
Why? If there's a link in the mind of the consumer, if the consumer is given an impression of a link which exists, which is not true, why does it matter what sort of link it is?
Yeah,
Well, I understand the point if the only impression the consumer is getting is a link which is true, for example, that you're selling old Argas, reconditioned old Argas that came from Arga. That's a true thing. There's nothing inappropriate about that. But
yes.
the point is, what if there is a link in the mind of the impression of a link which isn't true, which is what as I understand the judge's findings, that's what he found, because he found this connection through this e-control system. You're saying the only false link that's allowed is a link of the level of undertaking.
Affiliation.
Why is that?
BMW and DNIC.
No, why is that? Why does it make sense?
But it all comes from that, because it isn't just about receiving goods that may be original goods and selling them on. You must be an affiliate or have a special relationship. So it is relationship and status based rather than goods based, I think. Is what
But how does
you look
this
at the case
work in the context of the repackaging cases? Because the repackaging cases are all about a connection at the level of the goods.
Well, yeah, I mean, the repackaging cases don't come up as part of the foundation of this particular branch of Section 12.2. It's the three cases, it's BMW, then Viking, and then SodaStream. And they all say the same thing, which is that there's a status-based link between them.
But the very first authority you took us to was BMS and Paranova, which is repackaging.
Yes.
And it's the repackaging line of case law is constantly cross-referenced in the subsequent case law, isn't it?
I took you to that for the general principle that you mustn't interfere with the specific subject matter of the mark, which is origin, identification. That's true. But that does not contain detail on the meaning of Section 12.2 or the equivalent directive, and because that comes first in BMW and then is taken forward with Viking.
But the question, at some level, is about just because the fact is that on the facts of BMW, the connection in issue was about whether there was an authorised reseller, and on the facts of the other cases, the connection was whatever it happens to be. That's all true, and so the language of those cases is expressed by reference to that. So, of course, you're right, Mr. Malanis, that the connection, the particular connection in BMW that was being discussed was about at that level. But the question is, what's the legal principle? It isn't obvious to me why the legal principle has to be limited to a connection of the kind you're talking about.
Because we've got to leave behind the world of trademarks, because it's not just a trademark infringement, it is not the world of trademarks, but not the specific analysis that goes on with trademark infringement in relation to goods. We are looking specifically at false impression of a commercial connection in circumstances where these goods are legitimately being sold by third parties, including the impugned party.
But what you're positing is that a false impression of a commercial connection exists, and yet it doesn't matter.
It's not a material.
It's not a material false impression.
It's not a false impression relating to the identity or status.
No, I agree. I understand that.
That's
That's your submission. Is it's not a false impression about identity, but it is a false impression because the e-control system is not an AGA system or an AGA method.
So the other way of thinking about this, of course, is that even within the established principles, if my learned friend accepts that at some point in the transaction they know who they're dealing with, they find out who they're dealing with, and they know it's not AGA, that's the end of the inquiry.
Why? Why, if they have a false impression that the person they're dealing with that they know isn't AGA is using what they think is an AGA e-control system in the refurbishment?
Why should they continue? I put that back for and say, why should they continue to believe that when they find out that he's nothing to do with
I appreciate we're having a dialogue, but because they
the point.
didn't think that in the first place, because they thought you were AGA. They didn't think that. They thought the e-control system was an AGA system.
And that we're an official seller or something of that nature. I mean, this is
the way you market it.
Where
That's
does
what this case is all about.
Yes, I understand.
Sorry, can we just have a little look at Viking on this topic? So it's Authorities Bundle 1, tab 12.
Yes.
Viking Gas at paragraph 40.
Yes.
So in the first sentence, the Court Justice says this: the labelling of composite bottles and the circumstances which their exchange must not lead the average consumer, who is reasonably well informed, reasonably observant, and circumspect. So there is a connection between the two undertakings at issue in the main proceedings, that's your case, or that the gas used to refill those bottles comes from Cozen gas.
Yeah.
So why isn't that a complete answer to your submission? Because
they're the
that's saying if they think the goods come from the other party, that's enough. It's disjunctive.
It might be the facts of that case arise in that way as well.
But why is it a matter of principle? Does it depend on the facts of the case?
Well, it is not clear to partly because it is simply unclear what is persisting when the person knows who they're dealing with and knows that person has nothing to do with AGA. The person. If the person has nothing to do with AGA, on what basis do these goods have anything to do with AGA? That's the issue. So, I mean, all of these cases turn on their own facts. I think that is an answer to the point that that it's always got to be status-based. It depends on the fact. In this case, it is simply, given the flourishing trade, as I put it, flourishing trade in refurbished goods, and given that this a knowledge of a party will also give you information about what they do, the products that they make, and so on. What is left in terms of a misrepresentation or a false impression? It seems extremely unlikely that there's anything left. So far as the post-sale confusion point is concerned, again, I think I made this point in opening, which is that significantly, the post-sale confusion cases matter when there's no confusion at the point of sale, as in Montreux and Iconics. But you manage to show confusion after sale. But my learned friend's case is put on the basis that the badge plus AGA are sufficient to cause some sort of deception, or they didn't allege that in their pleading. It wasn't alleged as being an infringement at that stage. It was only in the post-sale confusion environment.
Sorry, I'm sure it's my fault. I'm not understanding the point you're making.
It's just rather unlikely that it would be a case that wasn't even put in the conventional way at the point of sale, given what they say about the website and the appearance of
Sorry, I'm sure it's my fault, but I'm struggling to understand the point you're making, because you started by talking about post-sale confusion.
Yes.
Which, as I understand it, is relevant to the respondent's notice
Yes.
argument.
I've gone back to it, yeah.
Well, I hadn't understood you'd even got onto the respondent's notice yet. So if you are addressing the respondent's notice, that's
Yes.
fine.
I'm
But I thought you were trying somehow to tie the two things together, and that was what I was struggling with.
I started my submissions by doing that. I say that the reason the judge gave for dismissing post-sale confusion was he said consumers know that products like this will bear other apparatus from third parties because they last a long time and so on. And that's perfectly sound reasoning so far as it goes, and should have been applied as well to the website. Consumers know there are electric kits out there. They've got no reason to think that AGA are engaged in a trade of electric kits, self-competing against their own electric ovens, selling refurbed items, self-competing against their new ones. And therefore that logic also applied to the website. So to that extent, I say the same thing as my learned friend. We both say we should win on both points. Not
Yeah, but
it should
then
be
we come back
decision.
to the point that I was putting to Mr. Selmy, which is that there's a clear distinction between the two scenarios. So in the scenario that the judge is considering at paragraph 56, he's considering just the goods where we've got the two trademarks on the goods separately, side by side if you like, but certainly separately. Whereas what's different about the website is it composite.
There is a single mention on a tiny white button once on the website. Everything else...
And on the invoices again.
The invoices, I don't want to get into that, but the invoices have got the additional feature of saying UK Innovations Group e-control in huge letters, you know exactly. So this tiny little word is said to have been so responsible for this massive misrepresentation. It does sound extremely far-fetched, but on that hypothesis, we would say there were better facts on the invoices and on the website. There was more disclamatory information, if you will, than there was even on the appearance of the cookers. That if they're going to be resolved one way, they should both be resolved in my favour. That's so far as they interrelate. Insofar as it's a sort of freestanding response on post-sale confusion, the point I was making was that the point was not taken as at transactional stage confusion. That's all. And it's very surprising for a case to be put on a post-sale environment when it was open to them to put a normal case. And it seemed it was not only a post-sale confusion.
This is probably me being slow.
Right.
Well, effectively was put at the point of sale because infringement was found.
Infringement in Brigade.
In other words, the website and the invoices, that's all prior to or at the point of sale.
Yes. Yeah.
So that's not post-sale.
No, but you had the cookers. When you sell the cookers, 26 cookers sold. There they are. When they're in the home, they're infringing.
Well,
but
that's,
when they're just being
but that's,
sold, they're not.
then we're into the respondent's notice territory.
Yeah, exactly. And so all I'm saying is it's just a surprising thing, because in cases where post-sale confusion matters, it's because there's some special circumstance happening at the point of sale, as in Brigade. There was, you knew you were in a Samsung.
Well, it does matter. This is what we're constantly struggling with, because the judge is dealing with the hypothesis, and rightly so, that what happens if he grants the injunction against the objectionable marketing? Does he go the extra step of granting an injunction that affects the goods themselves, or an order for damages? Same point. And therefore, what he does analytically is he asks himself the question, well, would there be confusion post-sale if there had been